C. This is A lives on the DH, B lives on the SH, and B grants the lease to C. No, don't make it a lease, make it a sale. Suppose it's a sale. And we just have these easements. Okay. Who holds the easementary right now?
C.
A? Who said A?
C.
A तो हो ही नहीं सकता. C. No, it's not C. Why? Because an easement can be transferred only by way of transfers of the dominant heritage. Okay. Only if the DH is transferred would that result in a transfer of the easement. If you keep on transferring the servant heritage, that does not result in transfer of easement heritage. Why? Because at the end of the day, it is the dominant heritage which is granting the easement. It is the servant heritage which is always claiming the easement. Okay. So if you execute a sale with C, the onus is upon C to go and claim that easement. But the only person who can transfer that easement is A. So if A transfers or sells his land to F, F can't deny to B the easementary right. Because why? That easement has stood transferred. Alright. Now why I am taking this example of two roads is, देखो, suppose this sale is executed to C. C does not want two roads. He just wants one right of way. If transfer of the servant heritage resulted in the transfer of both the easements, would C not get both the easements? If the transfer of this heritage led to any sort of transfer, sale, lease, anything, if the easements stood transferred by this parcel of land, then would both these easements not stand transferred to C? But we have to give the onus to this person, na? Ki which one do you want? Do you want one right of way or do you want two right of ways? Okay. So you can't burden him by giving him an extra easement for which he will have to pay. Alright. So you can't put that burden upon him. That is why easements can only be transferred by way of the dominant heritage. Alright. So this more or less is the notion of an easement. Now profit is something that is not that common in India. You will find very few case laws on this. I mean, you might find a lot of case laws which discuss this issue of a profit, but you won't find a lot of case law which actually addresses these issues of profits. Okay. Profit is similar in every way to a type 2 lease. Type 2. Okay. With the only difference being the degree of control involved. Alright. The degree of control is much higher in a type 2 lease. That degree of control does not exist in a profit. Let me take a very practical example so that you understand. What type 2 lease were we discussing that day? A farming one for the purposes of farming. Now if I grant you a type 2 lease for farming purposes, what are the obvious things that you could do?
It could be very specific, like farming only.
हाँ तो मतलब क्या क्या कर पाओगे आप? If I grant you that, हाँ? But what would you be able? You will be able to establish a boundary. You can
draw water from
Plant.
you can plant things. You can tile the soil. You can do a lot of things with the land in itself. If it is a profit, say something like the right to harvest, then the only thing you can do is harvest. You can't do any ancillary activity. If it's having any sort of ancillary activities attached to it, it will always be a type 2 lease. So what crops up, what actually causes the issue is that ये type 2 lease या profit समझोगे कैसे आप? Because the deed might say you are getting this. Okay. So what you have to test that on is the degree of control. If the deed just says that let this person be allowed to enter the land and extract oil, okay, then it is more in the nature of a profit. Why? Because the only thing he is allowed to do is get on the land and extract the oil. But suppose the deed says let this person continue with oiling activities on this parcel of land, then it's more in the nature of a type 2 lease, because it's not specific. Okay, it's giving a lot of discretion, a lot of control to the person who has been granted a particular right. So if the person who has been granted that particular right has a substantial amount of control, then it's a type 2 lease. Okay, otherwise it's a profit. Another issue that crops up is, I think someone asked it in the last class but they are not present today. I explained to you the distinction between a lease and a license. Na?
lease and rent.
So a rent agreement को सोच लो, that's a license. We call it in legal terms a license. आप समझोगे कैसे whether it's a lease or a license? क्योंकि आपके पास at the end of the day you will just get a document. All right. Saying these rights have been granted. Now, is it a lease or a license? That is the judgment you have to make. What would be the advantage if it's a lease?
Binds the whole world.
Correct. See, I am saying it binds the whole world, but in legal terms there is something called specific relief. आप लोग ये समझते हो? What is the distinction between specific relief and normal damages?
You get the same thing back.
Right, absolutely. In case of damages, you just get money, right? Liquidated damages, you get cash, or you get some sort of compensation. Okay. You don't actually get what was owed to you. In case of specific relief, आपको जो मिलना था आपको वही मिलेगा. Right? So if I terminate a license, what would the lessee get? Normal damages. But if I try and terminate a lease, what would the lessee go for? He would actually go for enforcement of that lease. I want to get my lease back. So I want specific relief. Okay. So if your interest is in specific relief, always go for something proprietary. Okay. Not something contractual. A license is contractual. Now, how do I understand from seeing the rights that have been granted whether it is contractual or whether it is proprietary? Basically, whether it is a lease or whether it is a license. क्योंकि इंडिया में लोग यही करते हैं. जितने वकील हैं सब लीज डीड में लाइसेंस ग्रांट कर देते हैं, लाइसेंस लीज के लीज ग्रांट कर देते हैं. समझ रहे हो? यहाँ पे अगर आप you go in Lucknow and try to take a house on rent, everyone will say that they are executing a lease, but they are not. Everyone in fact is executing a license. So how do you understand whether it's a lease or a license? What is the test? See, in simple terms, think of it in this way that you have to see the nature of the relationship. If the relationship is through the land, okay, that is, there is a grantor, there is a grantee. What is creating that relationship between them is the parcel of land, then it is proprietary. If what is creating the relationship between them is something contractual, okay, then it is a license. Now, suppose I have a house and I get a cook for purposes of cooking. उसे मैं कह देता हूँ तुम खाना बनाते मेरे लिए, तुम एक काम करो, तुम नीचे रहने लगो बेसमेंट में. I allow him to stay in the basement, and for these purposes we execute a deed stating that he gets to exercise all rights of stay in the basement. Is this a lease or is this a license?
License.
Why?
Because the association is through the service the cook is providing to the owner and not through the land.
Right. The nature of the relationship is, I am allowing you to stay in the basement. Why? So that you can cook for me. Because, as she rightly said, because you are giving me a service, the benefit I am giving you is that I am letting you stay. But if the situation were that I am exclusively letting you stay, not contingent upon your service, okay, I let a particular person stay, I let that cook stay नीचे, but I don't see जब तक तुम मेरे लिए खाना बना रहे हो. I execute a deed properly that you can stay in the basement. Okay, without the fact that he's a cook coming, he's my cook coming into play, then that would make it a lease. Why? Because then the relationship is between me and him and the basement. There is no third entity that is cropping up. If that third entity creeps in, then it makes it a license. Alright. Another thing you guys need to know is, if anyone says कि register नहीं करवाया, या register करवाना है या नहीं, everything needs to be registered. Everything, and you need to pay stamp duty on everything. 90% of the crowd here tries to avoid stamp duty and paying registration fees. But you have to do that. You have to get everything registered. What do I say by registered? When I am executing a conveyance for, say, a lease or a mortgage or a sale, we'll have that contract na, saying that this land now stands transferred. You have to go to the registrar and get that document registered. Okay? Every such conveyance dealing with the transfer of property has to be registered. Always go for registration should be your advice if anyone asks you. So, this is more or less everything that I was asked to cover. Do you guys have any questions? Any questions? No questions.
What are the restrictions on gifts? Have you told us that?
What I didn't understand? What is it?
The restrictions on gifts, in the sense that how much.
Whether